Good morning, Milad.
Good morning.
Nice to see your lordships after a long time.
Yeah. It's been a very long time. Yeah.
Announce, my lord, Chief Justice Madan, former Judge, Supreme Court of India, Honourable Chief Justice of High Court of Telangana, Sri Raghavan Chavanji, Honourable Rashek Reddy Garu, President of Board of Governors and Board of Governors, and all Honourable High Court judges, and my brother and sister judges. On behalf of Judicial of Telangana Judicial Academy, I would like to invite Honourable Justice M.B.Lokur, former Judge, Supreme Court of India, to address us on protecting the rights of victims in sexual violence cases, a judicial perspective. And Justice Rashek Reddy Garu would introduce the Honourable Guest Speaker today.
Yeah.
Milad.
It's my privilege to introduce my Lord Justice Lokur. My Lord Justice Lokur needs no introduction. My Lord was Chief Justice here for a brief period, but my Lord was so popular, my Lord doesn't require any introduction. But yet, it's my privilege to once again recapitulate my Lord's achievements so that it will be an inspiration for all of us. My Lord was an inspiration for me. My Lord was here, though for a brief period. Today, I owe a lot to my Lord because my Lord is responsible for what I am today. We can never forget my Lord. And coming to my Lord's achievements, my Lord was graduated in history from Stephens College, Delhi University, and also obtained degree from Delhi University, both prestigious institutions. And my Lord was enrolled as an advocate in the year 1977, practiced in Supreme Court, Delhi High Court, and had vast experience in civil, criminal, constitutional, revenue and service laws. My Lord was also appointed as editor, ILR Delhi series in February 1983 and continued till 1999. My Lord was designated as senior advocate in February 1997 and appointed as Additional Solicitor General of India in 1998 and continued as such till his Lordship was elevated as Additional Judge of Delhi High Court in the year 1999. My Lord was appointed as permanent judge on 5th July 1999. My Lord acted as acting Chief Justice of Delhi High Court for a brief period, and then my Lord was a Chief Justice of Guwahati High Court, and my Lord was Chief Justice of Andhra Pradesh High Court in the year 2011 to 2012. My Lord was appointed as Judge of Supreme Court in the month of June 2012. My Lord interest is in judicial reforms, computerization of courts, judicial education, legal and service, juvenile justice, and ADRs. My Lord was also member of Mediation and Conciliation Project Committee of the Supreme Court of India since its inception in 2005. My Lord was also in charge of E-Committee of Supreme Court of India even after his Lordship's limited office. That shows his Lordship's interest in computer-related matters and also for improvement of the technology and applicability, making applicable to the courts. My Lord was also appointed as one-man committee to suggest improvements in the working of the homes and organizations under the Juvenile Justice Act. My Lord laid down office on 30th December 2018, but my Lord is still a sitting judge, a non-resident sitting judge of Fiji Supreme Court, which shows that his Lordship interest towards the judiciary and also the institution. Today, and we should thank my Lord because on request, in spite of busy schedule, and my Lord was busy in arbitration matters, and a sitting judge of Vijay Court, in spite of all those busy schedule, My Lord easily readily accepted our request, which shows my Lord's love and affection and kindness towards the institution where my Lord has worked for some time. Though my Lord was elevated to Supreme Court, my Lord never has forgotten us. You have always maintained relations with us, and he was so kind, because I was fortunate to appear before my Lord, and I learned a lot. And you are inspiration to me, and you continue to be an inspiration to me throughout my life. And coming to today's topic, protection of rights of victims in sexual violence cases, a judicial perspective. My Lord was a pioneer, because my Lord touched these aspects in the famous judgment, the recent judgment in Nipu Saxena versus Union of India, wherein my Lord has dealt elaborately about this subject. And my Lord has selected a very good topic, because nowadays a very sensitive topic, because this protection of rights of victims in sexual violence cases is a more important aspect, because in spite of several legislations to curb the offences against the women and children, especially in sexual violence cases, still the offences are on the rise because of many factors. Because one of the factors is we are not protecting the rights of the victims. After conviction, we are nowadays in this Anglo-Saxon jurisprudence, we are only interested in protecting the rights of accused. No doubt, rights of accused have to be protected. But whereas the victims of sexual excess, especially in sexual violence cases, they stand, their body is abused, they are mentally abused, and their reputation in the society and their status in the society, the respect in the society, rape, what is the condition of a rape victim or sexual abuse victims. So it is now the time has come, and as such the legislature has introduced section 228 capital A of in the Indian Penal Code in the year 1983, and also the POCSO Code also provides several safeguards, and also the rights to the victims of the sexual rights of the victims in sexual violence cases. But yet these cases are not reported. Many of the cases are not reported. That is the reason the accused, they go on scot-free. And as a result, what is happening is there is a rise in the offences. So when we protect the rights of the victims, their privacy as well as grant of compensation, all those, if we protect them, the number of cases detected and reported will be more. As a result, we can curtail the crime rate. So today the topic being chosen is protecting rights of victims in sexual violence cases. Section 228 is very clear. It protects the identity, prohibition of identity of the victim, especially in rape victims. The offences under section 376 and 376 and 376A and so on and so forth, which will be dealt by Lord in depth. And the Nipu Saxena case, the rights of the victims and how the dignity and privacy of the individual victim has to be safeguarded elaborately, because the Supreme Court has approved the guidelines of the Calcutta High Court in Vijay case, and has also approved and made part of the judgment. And today, all judicial officers are dealing with several cases. I do not know how many offences are booked under section 228A. Day in and day out, we see any victims of sexual violence. The press and electronic media, we come out and they try to disclose the identity, because section 228 clearly deals, and the Nipu Saxena case is very clear. Any information published through electronic media, print media, or through social media, any form, if it leads to disclosure of identity of the victim, is punishable. The punishable offence, and a cognizable and available offence, punishable up to 2 years. I do not know how many offences are booked under this and how many are convicted. So this is one aspect. And coming to the abuse of children, the POCSO Act protects the privacy and also the safeguards, because the recording of evidence by the child victim could be wherever he chooses, wherever he is comfortable, and wherever the child chooses. That too by the women officer, not with the rank of sub-inspector. And at the same time, the victim is kept away from the accused, the presence of the accused, and also lot of protection is granted to the victim, a lot of safeguards. At the same time, though the enactment section 228A and also the Pope's Act provides for several safeguards, it is ultimately the presiding officer who is the man, who is the person who is manning the court, who has to safeguard the rights and privileges and also the dignity of the victims, because in several, we know in especially in rape matters, the defense will be so arrogant, and they will be while cross-examining, they will go to the extent of character assassination of the victim. So that is the reason many of the victims, they don't come forward to don't come forward to complain the same. And even while the court also, a lot of protection is required. Section 228A and also provisions of the Pope's Act provide for the same. At the time of registration of FIR, even at the time of filing charge sheet, and even at the time of even in judgments also, we are supposed to maintain the privacy, not disclosing the identity of the accused. All these aspects the judicial officers have to keep in mind while dealing this very sensitive matters, that is offences against in sexual violence cases that are against women and children. So the judicial officers should play an active role while conducting the trials in these matters. So this is a really very relevant topic which my Lord has chosen. And I'll not go deep into the subject because my Lord, who is expert in the field and has rendered an elaborate judgment touching all the aspects. And while coming to the compensation, you all know that Section 357 CRPC provides for compensation in respect of these victims. And also 357A also provides for framing of scheme by the government, as well as 357C also provides for treatment of the victims, other aspects. And as far as compensation is concerned, there is no specific statute, but only like in US where VOCA is there, Victims of Crimes Act. But in our case, we have provisions in CRPC 357, 357A and C also, where it provides certain rights to the victims. So there are several judgments which were referred to in Nikun Seksana, and the detailed guidelines were given how to protect the privacy and dignity of the victims, and also how to grant compensations, because these offences are not only against the victim but also offences against state and also society. Unless they are the victims come forward and complain and they are punished, there should not be any deterrence in the society so that their offences are not repeated again. I thank my Lord once again for acceding to request and participating in the webinar. And now my Lord will start the program. Thank you, my Lord.
Yeah, thank you, Justice Rajshekhar Reddy, and not only for the wonderful introduction that you've given, but also for the opportunity to come back to my former state where I was Chief Justice for a while, and to meet all the judicial officers once again. So thank you very much for this opportunity. And I hope in the future I get similar opportunities to address the judicial officers of Telangana through the Judicial Academy.
Yes, my Lord, we are always happy and with the Lordships. It is always homecoming for your Lordships.
Anytime, yeah, you can let me know anytime.
Yes, my Lord. Yes, my Lord. We are very obliged and
yeah, thank you. The topic on the rights of victims in sexual violence cases is actually a very vast topic. And the judgment that was delivered in the case of Mukul Saxena touches only one or two aspects of the entire gamut of issues. We have been talking in the past a lot about the rights of accused. Fair hearing, fair trial, this, that, should not be put in handcuffs, should not have bar fetters, should have access to lawyers, and so on. We've talked a lot about the rights of accused. There are also a large number of rights of victims, but unfortunately, we do not talk so much about them. And what is worse is that we do not actually even employ those rights of victims, and many of the victims don't even know that they have these rights. So I will be touching, broadly upon some of these issues to get an idea how judges should be in a position to deal with the rights of victims. The first thing really is about the registration of an FIR. Now, very often, in spite of the judgment delivered by the Constitutional Bench of the Supreme Court in the case of Lalita Kumari, very often there are still reports that FIRs are not being registered by the police. Now, I have come across judgments from Rajasthan, I have come across judgments from Tripura, the other end of India. And the position is the same in spite of the law laid down by the Supreme Court. Last week, the Supreme Court dealt with a case of a student of the National Law University in Jodhpur, whose body was found on the railway tracks or near the railway tracks. His friends, his parents suspected foul play, but in spite of everything, it took 10 months for the police to register an FIR. Right, and after 10 months, they registered the FIR. The investigation was very shoddy, and last week or 10 days ago, the Supreme Court passed an order saying that there should be a de novo inquiry, de novo investigation into the entire episode. Now, this happens in cases of murder. This was a possible murder. It could have been suicide also, but it could have also been murder. So, really, when you talk about registration of FIR in sexual offense cases, very often the police are reluctant to, register the FIR. Sometimes they say you go have a medical examination, and after that you come back, find out who is the person, give the name of the person, do a little bit of sharing of information. So there are many complications. So I think the first thing that we have to be careful about as judicial officers is to ensure that the FIR is registered, and if there is a delay in the registration of the FIR, the police has to explain. This does not mean that the victim can also take a long time, but it also does not mean that the moment a victim is raped, she should go to the police station and lodge an FIR. There's a mental trauma that is attached to it. There's a physical trauma that is attached to it. So don't expect the victim to just go rushing to the police station. But at the same time, it is the duty of the police to register the FIR the moment a complaint is made. There is a need for speedy and fair investigations. Now, the law says that you should try and finish off the investigation within a period of 2 months. But very often we know that the investigations go on for a long time. Sometimes they're not fair. It happens in sexual offense cases, it happens in other cases also. There are all kinds of pressures that are involved. We dealt with a case of children in Muzaffarpur, large number of children, 34 girls who were raped systematically in a shelter home. But the persons who were committing the crime were very influential persons. So investigations did not take place until the matter came to the Supreme Court. One of the persons who was involved was a cabinet minister. So there are these pulls and pressures, but it is absolutely important to ensure that the investigation is fair and that the investigation is expeditious. It should be done within a very reasonable period of time, 2 months, the legislature has said. But I don't know, sometimes the police take it easy. So this is also something that should be looked at very, very carefully. We must also look at a fair trial and an expeditious trial. Now, in the case of A.R. Antule, many years ago in the 1980s, the Supreme Court laid down the principle that the trial must not only be expeditious, that's a part of the human right of an accused, but the trial must also be fair. At the same time, I believe that when you're talking about an expeditious trial, it is also a human right of the victim. It is not only the human right of the accused person. The reason why I say that is that a person who is a victim of a sexual offense is entitled to get justice quickly. If a lady has been raped, you can't say that, well, the accused may get a fair trial quickly, but the lady can wait. It can't be like that. They're both on an equal pedestal. The victim is as much entitled to the right of a fair trial and the right of an expeditious trial as anybody else. Now, there are some cases that were, dealt with in cases of sexual offences by the Supreme Court on what is a fair trial. How do you ensure a fair trial? In 1996, in the state of Punjab versus Gurmeet Singh, that is 1996, two Supreme Court cases, page 384. The Supreme Court said that cases of sexual offences, they must be in camera proceedings. It should not be open to the public because there's a lot of shame that is involved. There is a lot of trauma that is involved. There is a lot of re-victimization that is involved. So for the benefit of the victim, you should hold in-camera trials, and equally importantly, the defense counsel should be prevented from asking questions that are humiliating. Sometimes just to humiliate the person, to intimidate the victim who has been raped or who is a victim of some other sexual offense, is to ask all kinds of unpleasant questions, to humiliate that person so that the morale of that victim breaks down, and she says, "Forget it, I am not interested in all this." That is a part of re-victimization. Sometimes the Supreme Court has said that if it is necessary, then you give the question in writing. And the court can then ask that question in a manner which is not offensive and where there is no intimidation in that sense of the defense counsel asking the questions. In 2004, in the case of Sakshi versus Union of India, that is 2004, volume 5, Supreme Court cases, page 518, the Supreme Court noted, and this is something which is correct, that very often the victim gets scared by the very presence of the accused person. Now, in our trial courts, the distance between the accused person and the victim is not so much. So they are actually, almost face to face. And you can imagine the plight of a lady who has been raped maybe a month ago, maybe 15 days ago, maybe 2 months ago, standing or sitting fairly close to the person who has raped her or committed some other kind of sexual offense. So she will have that inbuilt fear and will not be able to depose freely. So the Supreme Court said that you must have some kind of a screen that will keep the victim and the accused at some distance so that the accused cannot see the victim and the victim cannot see the accused. Or now today what we are doing in many places, including in Hyderabad, where you have a sort of a one-way glass. So the accused cannot see the victim. And if the victim wants to see the accused, she can see the accused person, but she knows very well that the accused cannot see her. So these are precautions that have to be taken. Now the questioning can also be, traumatic. So the Supreme Court has said in the case of Sakshi that you give a break. Maybe after half an hour, 45 minutes, 1 hour, that's entirely for the judge to decide. There should be a break of 5 or 10 minutes so that the tension in the mind of the victim goes away, or the victim is able to relax for those 5, 10, 15 minutes, whatever it is. So these are, these rights of victims which are built in through judgments of the Supreme Court, but we are not looking at them very carefully. Section 53A has been introduced in the CRPC about the medical examination of witnesses of the victim. So these are things that, judicial officers must be very careful about, must know that even victims have rights. Accused certainly have rights, but even victims have rights. There are victim protection schemes. We have dealt with that in Nipun Saxena. 228A of the IPC also talks about identity and so on. But you have victim protection schemes. Very often you come across cases where the victim of rape turns hostile. She says, no, nothing happened, or that it was consensual. Why does that happen? That is because she does not have the protection of the law. And the rapist is in a position to influence her. Sometimes there is social stigma. She doesn't know what to do. Her family and friends don't want to meet her. It is not her fault that she has got raped. She didn't invite the person to come and rape her. But our society is such that it becomes a stigma. So a woman who has been raped, she will be shunned by her friends, she will be shunned by her colleagues. That becomes a part of the social stigma that she has to face. That becomes a part of the humiliation that she has to face. So she says that, all right, I might as well turn hostile and say it was consensual, get married to the accused, and close the story over there. These are things that we have to be careful about. And that is why there is this need for protecting the identity of the victim. That's why the law says in 28A that do not disclose the identity of the victim. But today, what happens is that if there is a sensational case, the media, hundreds of cameras will go there. If it's in a village, they will go to that village with cameras, news reporters, and so on. They will talk to people around the colony, around that village, around the village area, such that everybody in the village comes to know that, oh, this girl got raped. They will talk to the father of the girl, or they will talk to the mother of the girl. And from the clothes that the father wears or from the clothes that the mother wears, the person can be identified. So there is a huge responsibility on the media. And unfortunately, although the law says that you should not disclose the identity of the victim, it's not that the identity of the victim should not be disclosed in the sense that the name should not be given, address should not be given. But what is happening is that the media gives so much of information that you can find out who is the victim. Fortunately, they have not gone to the house of the victim to get the address and say that, well, the victim stays at such and such place. I'm not naming the victim, but the address of the victim is so and so. So these are things that we have to be very careful about. The victim has a right of appeal that has come in through Section 372, but unfortunately, in my view, the scope of Section 372 is a little narrow. So, it can a victim can file an appeal if the compensation is inadequate, or if the person has been convicted for a lesser offense. But there is no appeal against a low sentence. So if the victim feels that 7-year sentence has been given, this is a case where 10 years sentence should be given. The victim cannot ask for an enhancement. On the other hand, the accused who has got 10 years imprisonment, he can ask for a lower in the appellate court. He can say that you reduce the sentence to 7 years. So the accused has an additional right for reduction in the sentence. But the victim does not have that right for enhancement in the sentence, which I think is a little unfortunate. Because if you look at them both to be kept on the same pedestal, then, well, if the accused feels that the punishment is so harsh, he can bring it down in the appellate court by appealing. Why can't the victim also say, well, the punishment is not harsh enough, according to me, it should be increased? So this is an area, that needs to be looked into. Recently, the Supreme Court dealt with this in the case of Parvinder Kansal on 28th of August. There was a decision that was given by the Supreme Court where they said that the victim does not have, the right to appeal for enhancement of the sentence. Of course, that was, a case where a case of murder, where the person had been given life sentence, and the family of the victim said that it should be enhanced to death sentence. So I'm not sure if the Supreme Court would have interfered in a situation like this in any case at all. But I don't think this logic should apply to cases where the victim feels that the punishment is low and it should be increased. Victim protection scheme has also been dealt with in the case of Mahinder Chawla versus Union of India. That is 2019, 14 Supreme Court cases, 615. Now, you see, in this victim protection scheme or schemes for compensation, there are a few problems. We had a case of a girl who was, I think she was about 13 or 14 years old, something like that. She had been raped by her uncle and she became pregnant. And well, the parents didn't want to, acknowledge that this girl had become pregnant, and then it was too late. This girl still did not know that she was pregnant because her parents were telling her all kinds of stories. And ultimately, this girl had to give birth to a child. Now, we wanted to know from the Legal Services Authority about the compensation that is to be paid to her. So the member secretary of the Legal Services Authority appeared in court, and he said that it will take 2 or 3 months to give the compensation. So we asked him, why will it take so much of time? So he said her number is 31. There are 30 other cases that are pending for grant of compensation. Now, then we told the member secretary that, listen, if these cases are going to remain pending for months together, then the whole purpose of giving compensation sometimes might get lost. So there has to be some method of expediting the release of compensation. So the member secretary said yes, he would look into it. He would speak to the judge in charge of the legal aid, judge from the High Court in charge of legal aid, and work out some system. So my request to the judicial officers also is this, that when we talk about compensation to victims, when we talk about protection of victims or protection of witnesses, we have to look at it from the point of view of the victim also. There is no point in a victim being told, all right, you come after 3 months, your hospital bills and so on and so forth, whatever it is, we don't know. Come after 3 months, 4 months, we'll pay you a little bit and then let us see balance also we'll give you. It can't be like that. These issues have to be dealt with compassionately. I think this is a very, very important aspect, that compassion must be there, empathy must be there among the judicial officers to realize that the victim has gone through a problem, has gone through a trauma, and something must be done to try and alleviate the pain and the suffering that the victim has undergone. So these are, issues of very, very grave importance, and we deal with them on a daily basis. Now, this issue of compensation came all the way up to the Supreme Court. So the trial courts have to deal with it, daily. And there are so many cases. I was just reading 2 days ago in Delhi, in the year 2018, the figures are of 2018, 2019 figures have not yet come. In Delhi, every day there were 5 rapes on an average. 5 girls were being raped in Delhi every day. Now, that figure is about 2,000 something the total number of rapes that have been registered. There may be many that may not have been registered. But anyway, the ones that have been registered, you can imagine the burden that the legal services have to undertake, in terms of payment of compensation. So some method has to be evolved, try and get some method through which, the compensation is given quickly to the girl or to the family. In this case of this 13 or 14-year-old girl, she had to look after the child also. And because of the mother's age, I'm sure the child would have been, below weight. Nutrition would have been a problem. There would have been a lot of other problems also. So let's look at it sympathetically. Let's look at it compassionately. Let's look at it with empathy. Social stigma, I have already mentioned. I think the preservation of the identity is important, not only for the fact that there is a social stigma involved, but also the dignity of the person. That is very, very important. And Article 21 of our Constitution talks about, the language does not talk about it, but the judgments of the Supreme Court mention about stigma, mention about dignity. So the dignity of the person has to be preserved. So, look at the whole scenario, right from the beginning, from the time of registration of an FIR, investigation. Has it been fair? Has it not been fair? Trial. Are we as judges ensuring that there's a fair trial? Are we as judges ensuring that the trial is carried out quickly? Are we as judges, ensuring that the victim is given protection? There is no stigma. Witnesses are given protection so that they don't turn hostile and say that nothing happened. So there are a lot of issues, that we have to look at. Now, legal aid, I think, is in this context very, very important. Now, unfortunately, the figures that have been released by NALSA, they indicate that out of all the beneficiaries under the persons who have come for legal aid, legal advice, legal services, only 25% of them are women, right? And unfortunately, it is the women who have to bear the burden of our legal system. They are the ones who are more badly affected, but only 25% of them are. Is it because there is little faith in the justice delivery system through the legal aid? Are we paying adequate attention to legal aid? Are we giving quality legal assistance? Are we giving these women who come, are we giving them the confidence that the legal aid will do the best that they can for any victim in terms of prosecuting the case, in terms of giving correct legal advice, in terms of follow-up? After all, this lady who has suffered a sexual offense, a crime involving a sexual offense, has to try and live normal life, come back to normal life. That's where legal aid helps. You need support persons. You need persons who can counsel the victim. We don't look at that. We think that, all right, this lady will take care of herself, or maybe her family will take care of her. No, but the family is not, professionally trained. A support person is professionally trained. A counselor is professionally trained. They are the ones who have had to deal with so many people that they know how to deal with another victim of rape. Why do we go to a doctor when we are not well? Because that doctor is professionally trained. We don't go to our family and say that, listen, I have got a stomach ache or I've got fever, now you give me some medicine. What is the family going to do? So then there is a need for professional training, professional persons being involved in these kind of cases, whether they're support persons, whether they're counselors, Victim-friendly courts. Supreme Court has already said there should be a screen. I have seen in Hyderabad, there is a one-way glass that has been put up in that Purosa. These are things that we have to look at. Make the courtroom comfortable for the victim. So that the victim doesn't have to sit on a chair which is uncomfortable or stand, somewhere at the back. Why can't the victim be comfortable? Why can't we look at our witnesses, as persons who they're not involved in the crime, they're just witnesses. Witnesses are neither accused nor are they victims, but we don't treat them properly. Any one of us can be a witness to a crime. Tomorrow, if there's an accident and I happen to be on the road, I will become a witness. And then to tell me, no, you better come, 3 times in a week, or you come 4 times in a week, or you wait for the whole day. When your turn comes, I will examine you. Whatever, I have not committed any crime. I'm not the victim. I'm not the accused. But then I have to suffer this problem. There's payment of, the dues to the witnesses. I know when I was in Guwahati, very strange, in one of the states, the rule was that the witness, when he comes to court, he has to attend the court and he has to give a certificate to some accounts officer that he has attended the court, and this is the amount of money that he has spent for the bus fare. The accountant will keep that paper with him and he will tell him that you come tomorrow to collect the money. So this fellow has to come again the next day to collect the fare. So he has to take 2 trips to collect the fare for 1 trip. Now, what sense, does it make? So we have to give that importance to the witnesses also, because they are, as Jeremy Bentham had said, they are the eyes and the ears of the justice delivery system. And if we just cut off the eyes, we cut off the ears and say, no witnesses are required, our justice delivery system is going to collapse. So look at the whole thing, in a broad manner. Now, I would like to just address also on, some special challenges that are faced not only in some of these kind of cases, but in cases pertaining to POCSO. You have child witnesses, a child who has been child victims, a child who is 4, 5, 6, 7 who has been sexually abused. What does that child know? How is that child going to depose? We need to think about it. Now, NIMHANS in Bangalore, they've done a lot of study. We had taken their help with regard to those young girls in Muzaffarpur who were raped, Bihar. Many of them were young girls, 10, 12, 13, 14. Many of them didn't even know what was happening. Some of them were given drugs. Some of them were beaten unconscious and raped. They didn't know what was happening. And then you say you go to the witness box, get cross-examined. What are they going to say? What is the judge going to understand when the witness says, I don't know what happened, or I can't explain what has happened, or I don't know the consequence of what has happened? That's where, again, professionalism comes in. So when we are dealing with child witnesses, it's a very, very difficult task. And we as judges need professional assistance. We can't say that, well, if I put the child on my lap and, ask the child some questions, give her chocolate or give her toffee or something, the child will be comfortable and will answer. Maybe, but maybe not. How is a child of 5 years, and there are so many cases of children who are 5, 6 who have been raped. How is a girl of 5 years going to explain that she was raped with a defense lawyer cross-examining her? Can you imagine what the child is going through? These are some challenges that we have to be, very, very aware about. Physical trauma is there, mental trauma is there. And then we add to it, what is now called re-victimization. Then there are cases of most of the rape cases, as high as 80%, if not 90%, where the person who has committed the rape knows the victim. It could be somebody from the family, it could be somebody who is a colleague, it could be somebody who is a friend, it could be somebody who's a neighbor, or somebody living in that colony or nearby. Now, if a person is raped by somebody from the family, it is not only a stigma on the girl, it is a stigma on the family. The family will not admit it. Why? Because it will bring shame to the entire family that you have a person like this in your family. So many cases do not get reported. So in many cases, the rapist gets acquitted, either because of the witness turning hostile, or because the family does not want to be serious about the prosecution. Same thing happens with a child witness. A child is raped or molested by an elder, probably in the family, because the child doesn't go out here and there in the colony goofing around. 5-year-old girl, a 6-year-old girl. The chances are she is being raped by somebody in the family. Who will admit it? That yes, this person raped a 5-year-old girl. It's a huge, huge challenge. And judicial officers have to somehow or the other meet that challenge. And that's where you require professional assistance. Doctors are told, and there are many instances under the POCSO Act, if a doctor comes to know that a child has been raped, it is his responsibility to inform the police, even if the parents don't inform the police. And if the doctor does not inform the police, the doctor can get prosecuted. Now, what is the doctor supposed to do? He will say the family is pressurizing me that do not disclose what has happened. It will bring shame to the family. It will cause stigma. That child's life will be ruined. After all, she's a 5-year-old girl. How is she going to live the rest of her life like this? Doctor's caught in a dilemma. On the one hand, the law tells him that no, you better report, otherwise we will send you to jail. That's and on the other hand, you have the family saying that listen, if you say all this, then what is you're going to ruin us? We have faith in you, and now this is what you're doing to the faith that we have in you. You're going and telling the police everything. These are challenges. Sometimes you might come across cases where, well, the doctor himself may turn hostile. So these are issues that we need to think about. How do we deal with them? These are day-to-day matters that come before the judges. Like I said, in Delhi, 5 rapes a day. I don't know what it is in Telangana, what it is in Hyderabad. It may not be as much as Delhi, but even if it is 1 rape a day, that's quite a lot. That's 365 cases. So we as judges have to be equipped to deal with these kind of cases. Now you have new kinds of issues that are coming up. Live-in relationships. So something goes wrong in that live-in relationship, and the girl who is probably an adult will say, "Oh, this fellow raped me." How is the judge going to determine that? Whether it was consensual or whether it was rape? How is the judge going to do that? Sometimes in these live-in relationships, the girl and the boy run away. Why? Because there's opposition from the family. And they're found in some other city, maybe in some other state, and the police track them down. The girl's parents say that, well, the girl was kidnapped. The girl says, yes, 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 I was kidnapped and I was raped. The whole thing may be consensual. One doesn't know. Again, it's a huge challenge for the prosecution. It's a huge challenge for the judge. Why? Because the girl is taking one stand. Sometimes the girl is brave enough to say that, no, I ran away willingly. I'm an adult. I can do what I want. I don't care what my parents think. Sometimes they're not brave enough to say that. The parents will tell them that, listen, you leave the house, go and stay with whomever you like. That fellow doesn't have a job. What is she going to do? So again, it's a huge problem for the judges. I think these are issues that we need to look at. And now we have this recent case of this girl from Bollywood, from Bombay, where it's not the girl's parents who are saying anything, it's the boy's parents who are saying that this girl caused the son to commit suicide. May be right, may not be right, I don't know. Investigators will find out. But the relationship was a consensual relationship. Maybe something had gone wrong. If a matter like this comes for trial, how is the judge going to decide all this? Maybe the live-in relationship broke up. Maybe there was a quarrel. Evidence will have to be led. And then suddenly, because it is a very sensational case, newspapers will be talking about it, media will be talking about it, and the judge will come under pressure. What am I supposed to do? So I think we need to discuss many of these things. Then there are other kind of offenses that arise. Molestation, sexual harassment at the workplace. How do you prove that? It's not that it happens in the presence of witnesses. We had some time back this Me Too movement, where ladies who were harassed, claimed that they were harassed at the workplace, made allegations. Today there's a trial going on where the person against whom an allegation has been made, sexual harassment, he has filed a case for defamation. He says nothing like this happened. This girl is just trying to take advantage, get publicity, so on and so forth. So the girl is dragged to litigation, dragged to the court. The case has been going on now for about 2 or 3 years. It will go on, appeal and all that, for another 4 or 5 years. Now, assuming for the sake of argument that what this girl is saying is correct, she's in the courts for 5 years. What for? For establishing the truth. She's had to spend money on lawyers. She's had to spend time in the court. She's had to be cross-examined on all kinds of things. So the whole problem of victims' rights, in cases of sexual offences, and there are all kinds of sexual offences that we can talk about. We've talked about rape. We've talked about molestation. We've talked about sexual harassment. Now, I don't know. I think the judicial academies will have to take up this very, very seriously, because now we are getting information. Of course, it has been there, but we are now getting information through the National Crime Records Bureau about the magnitude of the problems. There is a media that is breathing down the neck of the justice delivery system. There are people who are talking about this. Why is justice not being delivered? And if justice is being delivered, why is it being delivered after so many years? What about the investigation? Is that investigation fair or is it not fair? Everything is known. Trial, is that fair or is it not a fair trial? So these are, a large number of issues that keep arising, and judges have to be equipped. The judicial academies, in my view, should take it up very, very seriously, because this has a very huge impact on society. You can imagine now in Delhi, 2,000 girls have been raped, alleged to have been raped in the year 2018. Take another 2,000 in the year 2019, another 2,000 in the year 2020. You will have 6,000 girls in the city who have been raped. What kind of a society are we producing? So judicial academies will need to look into many of these issues, starting right from the time of registration of the FIR. The problem starts when the FIR is not registered. Why is it not registered? And it ends when the appeal is decided. So it's a huge period which encompasses investigation, trial, appeal. At all times, the accused does have rights, but we must remember that at all times, even the victim has rights. We must remember that it is society which is ultimately impacted. Whether there's a conviction or there's an acquittal, it doesn't matter. The very fact that such a thing is said to have happened is an impact on society. That's what we have to look at. So when we talk about social, context judging, this is what is social context judging. What is the kind of context in which a particular event has happened? Why has it happened? And what can we, as judges, judicial officers, do something? So I'm very glad. I must congratulate you, Justice Rajshekar Reddy, and of course to the Telangana State Judicial Academy for taking this initiative. It's a very, very important topic of discussion, and I hope progress from here to try and give justice through compassion, through empathy, so that the lives of women victims of sexual offences, whatever kind, it could be rape, it could be sexual harassment, it could be molestation, cyber crimes. We have a large number of cyber crimes. Today's newspaper here in Delhi says that during this COVID period, the number of cyber crimes, not necessarily involving sexual offences, number of cyber crimes has gone up by 500%. Can you imagine? 500% increase in cyber crimes. Now, surely some of them would be related to sexual offences, pornography, child pornography. Are we equipped to deal with all that? So, thank you very much, and all the best. And keep these topics alive and discuss them for the benefit of our society. Thank you very much.
Any questions?
Thank you very much for your illuminating and in-depth and analysis of the subject and enlightening us on the subject and all of our judicial officers. And I want to add a few words what my lord said. My dear judicial officers, my lord has shown so much of concern to the victims victims in the sexual offences cases. So because many officers may think that huge pendency, so many cases are pending before us, how can we devote time to that? Now for that, government has constituted separate POCSO courts, special courts, and separate special courts for offences against women. And as far as possible, we are posting women officers in these posts. No doubt, it is a very difficult task because administration of justice is a very sacred duty conferred upon us. People come to us with problems only. So, first we should be cool and stable for entertaining this task. It's not an easy task. And if you consider this as a job, it's very difficult to perform. If you consider that it is a sacred duty, you should have, then only you can perform the duty. You should love this job. You should have a passion to do justice. Then only you can certainly do something. As my Lord said, while dealing especially this, while dealing with victims, you should know this how we can't describe. My Lord has put it in so many words, and no language can be sufficient to describe their state in which they are living and the trauma they have undergone. So it's only we should, as a member of the society, we should understand and deal with them. There are several laws, no doubt there are several laws. Ultimately, it is the judges who man the courts, who should be sensitive towards their problems, sensitive towards their feelings. Then only the laws can be implemented. Any number of laws, because Nirbhaya Act has come, several acts have come, but still, as my Lord said, reporting of the offences are on the very low side because of several factors. Stigma, so many factors, because again, the girls will not get married, so many things are there. But the only thing is, if you give them privacy, lot of dignity to the witnesses and also the victims, because I have seen as a citizen, as a lawyer, victims come to the court, witnesses come to the court, accused come to the court. I don't think there is any differentiation. All of them sit at the back. Practically come to the court when it comes to the court. Luckily now we have established 2 or 3 POCSO courts where some environment we have created, child-friendly environment, so that child can depose. But the only thing is we have to develop a lot of infrastructure. And I request all the judicial officers not only to concentrate on judicial side, to also concentrate to see that our infrastructure is improved, so that the environment, especially in these courts, we should create an environment. So that when a person comes to the court, they don't have toilets, they don't have waiting rooms. They have to sit there in the whole day in the court. Whether they like it or not, they have to hear all this, what is happening in the court. Because what happens in the court is only litigation. It's not a pleasant thing to sit there and hear. So these sensitivities should be kept in mind by judicial officers, and it should play a role for development of the infrastructure, especially these courts and other courts also. Now even the commercial courts also, recently I have seen, they have developed this. It's not like other courts, because the person who comes to the court, he should be comfortable, because already is under injury. Whether it is in sexual violence case, other cases, he'll be injury. He's in trouble. He's in litigation. He comes to the court. What is the environment we are creating there? So please, my dear judicial officers, concentrate on these aspects and take the clue and the guidelines and also the concerns expressed by my Lord, and also see that you implement the concerns expressed by my Lord. Thank you, my Lord, once again.
Mr. Millard, it is my proud privilege to propose vote of thanks on behalf of the Telangana State Judicial Academy. Millard, under the guidance of Honourable Chief Justice and Honourable Justice Rajshekar Reddy garu, we have been conducting several webinars, almost all on every Saturday, inviting several legal luminaries for the respective topics, Millard. Today, Millard, on the request of our Honourable President Rajshekar Reddy garu, your Lordship delivered lecture on this topic and enlightened us thoroughly, Millard. And a thought-provoking, the debate is also led on the Judicial Academy's role, particularly taking into consideration of the number of cases registered and about the fair trial and fair investigation and compensations to the victims also, Millard. And Millard, there is a provision under section 15A of SC/ST Act. This legal provision is not couched in the POCSO Act. That is also a debate to be raised, and it is to be reported to Millard. Because the victim in the SC/ST Act has every right at the stage of bail, at the stage of conviction, at the stage of punishment, etc. also, Millard. But in the POCSO Act, there is no such provision. That it is also to be looked into further. And my lord, for sparing your lordship's valuable time on the Saturday and enlightening us on this topic. And myself, on behalf of the Judicial Academy, on behalf of the President and Board of Governors, and on behalf of the Telangana High Court, I thank you, my lord, for addressing us. Thank you for all the officers. Thank you, my lord. Thank you, our Honourable President Rashekar Reddy Garu, giving me opportunity to propose vote of thanks. Thank you, my lord.
Okay, thank you. Thank you very much.
Thank you.
We'll again invite your minority.
Sorry?
Again, we'll ask your, again, we'll have your.
Yes, anytime.
Yes.
Okay, thank you.